The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
What is the Fourth Amendment?
Oh, it's the one, the right to remain silent.
No.
Is that the fifth?
I haven't learned that yet.
The Fourth Amendment is the no unreasonable search and seizure without probable cause. Okay.
Yes, I remember that now. Thanks, Mr. Snively.
What do you think probable cause means or entails?
That somebody has reason to suspect something.
If you do something, you will probably end up needing to be searched. So, like, if you have like an illegal drug or something, maybe like it would be there. It's a probable cause that you will need to be searched.
That there needs to be some kind of some empirically based basis in order to enter someone's private residence.
An example scenario. A school official thought a girl going to school had possession of cigarettes in her bag, but he did not see it. Does the police have the right to search her bag?
No, because he doesn't have reason to suspect anything.
But he did not see them. Does the police have the right to search her bag?
Yes,
Why?
because if she does have cigarettes, then he's made a good move and he's helped the community.
Does the police have the right to search her bag?
What's his? I don't know his evidence, so I really can't tell about that. If he doesn't like see anything, then maybe keep an eye on anything. But so I'd say no.
I wouldn't take the school officials' badge of authority as the be-all and end-all reason for allowing things to progress, right?
Does the police have the right to search her bag?
No, because he doesn't have a reason. If he just thinks it, it's not evidence. There's no evidence.
He smelled like the smell of cigarettes on her. Does he have the right? So his probable cause is that he smelled it.
She could simply live with someone who smokes. No, I'd say probably not.
Okay.
Possibly, that's a tricky one. The student could have smoked earlier and left the cigarettes at home, or the student could have been at a bus stop where a lot of people were smoking. So I know you probably want a yes or no answer. Again, I would want to, as a school official, possibly try to follow up before just making assumptions.
Does sense of smell count as probable cause? So if the police smelled it on her, smelled cigarettes.
Yeah, sure.
No, because it could have been from someone else, but it doesn't mean it's from her.
But it's just probability. It's a possibility, so yeah, I feel like it would be.
Does a cop have a right to search someone he deems sketchy outside a public place?
No,
Or not?
because that's where we get into like the racial profiling, and that's when you get into gray areas.
Does a cop have a right to search someone he deems sketchy outside a public place?
Not technically.
Okay. Does a cop have a right to search somebody he deems sketchy outside a public place?
No,
No. Okay.
that's subjective. What does sketchy mean, right? And too often studies have found that perceptions of sketchiness are based on ethnic, racial, and socioeconomic factors. So no, I don't think that sketchy on and of its own. I don't trust gut instinct, right? When it comes to these things, there needs to be something more empirical than just gut instinct.
Search somebody who he thinks is sketchy if they're like outside a public place.
And that operates for people's visual typing and stereotypes. So I'd say not based on that alone. Just look sketchy? No, probably not.
3 men are pacing outside of a jewelry store and they look nervous. Police officer asked them what their names were and they mumbled something really quickly. Is that sketchy? Does he have the right to search them? Okay.
Yes.
The New Jersey versus TLO case was about a student's right to privacy on school grounds. A school official assumed that a student had cigarettes in her bag because she was suspected of smoking in the bathroom. He had never actually seen them, but he still felt that his suspicion and his sense of smell was enough cause to search her bag. Once her bag was searched, the school official found drug paraphernalia, marijuana, and documentation of drug sales. The student, after being charged with possession of marijuana, protested and stated that the official had no right to search her belongings without a warrant or probable cause. The U.S. Supreme Court ruled against her, saying that the search was reasonable because the student was on school grounds, and that means that the officials had the right to search her bag. This case set the precedent that students on school grounds do not have the same rights against unreasonable search and seizure as normal citizens do.
In the Mapp v. Ohio case, Mapp's house was broken into by cops who claimed they had a warrant to search her possessions. They found pornographic material not pertaining to the investigation and took it as evidence, charging her with possession of obscene materials. This case made it all the way to the Supreme Court, where the justices decided in favor of Mapp because the officials were so obviously in the wrong. In this case, the Fourth Amendment rights of the citizen were protected. The decision in this case dictated that no matter what an official finds, if they stepped through someone's door and obtained it without a warrant, then the citizen's rights were violated. The Supreme Court refused to allow the use of the evidence because it was unconstitutionally obtained, which is known as the exclusionary rule.